Good afternoon. Welcome to Lunch with Books. My name is Sean Duffy. I'm your host from the Ohio County Public Library. Today, the topic is Seceding from Secession, the Civil War, Politics, and the Creation of West Virginia. It's a new book by Eric Wittenberg, who's with us today. Judge Edmund Sargus, who's from St. Clairsville, also with us, both from Columbus, I believe. The third author is named Penny Barrick. She is not with us today. I'm going to introduce the guests who are here. Judge Sargus serves as a federal district judge in Columbus, Ohio, worked as a U.S. attorney, and since 2005 has been an adjunct professor at the Moritz College of Law at Ohio State University, the Ohio State University. Eric Wittenberg is an American Civil War cavalry historian and author. He is an attorney and has authored over 21 books on various Civil War subjects. We're going to start with Eric, so I will say goodbye to Judge for now, and I'll go away as well, and here is Eric Wittenberg.
Thanks, Sean. If you want to go ahead and fire up my PowerPoint, please. Good afternoon, everyone. It's our pleasure to be here today. We're going to be talking about the events that led to the creation of the state of West Virginia. I'll be talking about some of the historical stuff that took place up to and including the end of the American Civil War, and then Judge Sargus will take over and talk about the constitutional law issues that are very pervasive in this conversation. So let's get started, shall we? This is what Virginia looked like at the outbreak of the American Civil War in early 1861. As you can see, the state was much larger than what it is today, and as you can see, what we now know as West Virginia was included in the state of Virginia. Now, it's important to note that there is a almost visible dividing line, and that almost visible dividing line is the Allegheny Mountains that run on a diagonal and help to establish the boundary of the Shenandoah Valley. Pretty much everything to the east of the Allegheny Mountains constituted what we consider the traditional tidewater agricultural part of Virginia that had its ties to the first families of Virginia, had its ties with the Deep South. To the west of the Alleghenies, most of the commercial ties were with Maryland, Pennsylvania, and Ohio. Those counties were closer. There was a physical barrier in between. The Ohio River, which constituted the western boundary, constituted a major source of traffic for commerce. And the people of the western part of what was then Virginia felt much closer ties to their neighbors in Maryland, Pennsylvania, and Ohio than they did to the tidewater plantation owners that owned slaves in the eastern part of the state. And for the most part, the yeoman farmers of the western part of the state of Virginia were not slave owners. They didn't have a largely agricultural economy the way that the eastern part of the state did. For one thing, the terrain didn't permit that, but for another, it just simply were not as wealthy and there weren't the large plantations. So you don't have that common bond of slavery, and there was always a perception that the people of the western part of the state were subservient to the people of the East, in particular during the negotiations to redo the state constitution in 1850, when certain taxation credits were given to the slaveholders in the eastern part of the state that were basically carried and paid for by the people in the western part of the state who did not have the benefit of being able to collect the benefit of those tax breaks. So there was an awful lot of animosity between the people in the western part of the state and the people in the eastern part of the state. And for years, there'd been some itching for people to leave the Commonwealth of Virginia and establish a separate state that would take place in the western counties. Things came to a head with the election of John Letcher as governor of Virginia in 1860. Letcher took office in early 1861 and immediately upon taking office called for a secession convention, the purpose of which was to debate an ordinance of secession with the hope of leading the Commonwealth of Virginia out of the Union. This convention was to be held in Richmond. All counties would have delegates. Letcher, even though he was supposed to not be on the side of secessionism, made it very clear that that was where he wanted to go, and made it very clear that the secession of the Commonwealth of Virginia was the objective. It was made very clear by the people of the western counties that they were not at all interested in leaving the Union, and that if Virginia voted to secede from the Union, it was quite likely that they would not go along. So this set the stage for what will become a lot of controversy. That secession convention was called in the early months of 1861, excuse me, and up until the troops of the state of South Carolina opened fire on Fort Sumter in Charleston Harbor in April of 1861, the ordinance of secession actually was not gaining favor and was on its way to being a losing proposition until such time as the firing at Fort Sumter took place. And then the tide began to turn, and eventually the convention was called upon to vote on the ordinance of secession. And present at the ordinance at the secession convention, among others, was John Tyler, the 10th president of the United States, who was an ardent supporter of secession. And in fact, when the ordinance of secession passed, there were observers who commented that they saw Tyler sitting in the gallery weeping with joy over the passage of the ordinance of secession. Another speaker at the convention, who was quite the hellfire and brimstone type, was former Governor Henry Wise. Henry Wise was the final speaker before the ordinance of secession was put to a vote. He laid a gun on the table in front of him and whipped the crowd into a frenzy over secession. And when the voting took place, as indicated, Virginia approved the ordinance of secession. This was in April of 1861. In order for it to become effective, there had to be a statewide referendum to approve the secession, and that was the next step. In the meantime, and that was scheduled for May of 1861. In the meantime, this is a photo of later in life of Archibald Campbell, who at the time was in his early 20s and was the editor and publisher of the Wheeling Intelligencer newspaper. And Arch Campbell was one of the leading advocates for the secession of the northwestern counties to form their own state. And he began using the bully pulpit of his newspaper as being a primary means of whipping up support for this entire idea of the western counties of Virginia seceding and forming their own state. And in part due to his efforts, and in part due to organizational efforts that took place in the various counties of what make up today West Virginia, there was to be a secession convention held in Wheeling at the Customs House. This is an image of the one of the two Wheeling conventions that appeared in Harper's Weekly newspaper. It shows the Customs House. The first convention was held to discuss a game plan of what would happen if Virginia did in fact secede. And during those events, John Carlisle, who was a Westerner, began advocating for the creation of a new state. He was in fact the earliest public advocate for the creation of a new state of West Virginia, and in fact raised that issue at the first Wheeling Convention. It was, however, determined that it was premature. So the decision was made that if the referendum on the ordinance of secession passed, a second Wheeling Convention would then be scheduled for the month of June, where a number of items would be discussed, including, but not limited to, John Carlisle's idea of creating a new state. So that's the first convention. Then another early statehood was excuse the typo, Waitman T. Willie, not Waltman. These are two of the leading lights on the whole idea of secession for West Virginia. And when the referendum passed in May, the second convention was held. And the second convention was held in Wheeling, again at the Customs House in June. And a number of steps were taken at the second Wheeling Convention. First and foremost, it was declared that because John Letcher and the other elected officials of the Commonwealth of Virginia had supported the idea of secession, they were traitors. Because they were traitors, they had abandoned their elected offices, and the Wheeling Convention declared the offices of governor, lieutenant governor, attorney general, and state treasurer open. They then formed what they called the Restored Government of Virginia. And this man, Francis Harrison Pierpont, who was from Morgantown, was appointed the governor of the Restored Government of Virginia, and who supposedly then had the authority and the power to speak for the entire state. This sets the stage for some of the constitutional law issues that we'll be exploring later. Once the Restored Government of Virginia was established, then was raised again the idea of secession of those western state counties to create a new state of West Virginia. Now, not to steal too much of Ed's thunder, I will touch on one thing, which is there is a provision of the United States Constitution, and Ed will talk to you about it in more detail, that allows for the creation of a new state from an existing state, provided that both consent to it. And this is where the problem is going to arise. This effort to create a new state of West Virginia will be basically self-dealing. And we'll come back to that. Because the two Virginia seats in the United States Senate were also declared to be abandoned and open, Waitman Willie, excuse me, and let's go back here. We'll see Willie and our friend John Carlisle will be the two who were appointed to fill those seats. And interestingly enough, almost as soon as the engines were put in motion to create a new state of West Virginia, John Carlisle's tune changed, and he suddenly became opposed to it and resisted the activity at every opportunity, including to the point where people called on him to resign, and he refused to do so. But steps began to be taken. This is John W. Garrett, who is the president of the Baltimore and Ohio Railroad. Excuse me. John Garrett will play a critical role in these events because it's fair to say that if it wasn't for the Baltimore and Ohio Railroad, there would be no state of West Virginia. Garrett was a Marylander, but he was very involved in everything pertaining to the American Civil War. This map shows in red the route of the B&O Railroad, which, as you can see, begins in Baltimore. It then passes through Harper's Ferry. It goes to Cumberland, Maryland. From Cumberland, it goes on to Wheeling. From Wheeling to Newark, Ohio, Newark to Cincinnati, Cincinnati on up into Indiana, and finally ending in Chicago when it was extended further west. Originally, it ended in Wheeling. It was eventually extended into Pennsylvania. The Baltimore, into Ohio. The Baltimore and Ohio Railroad was the critical line of supply for the United States armies operating in the Eastern Theater of the Civil War. The vast majority of supplies were shipped east on the Baltimore and Ohio. Troops were transported on the Baltimore and Ohio. So consequently, maintaining the security of that railroad and making sure that it remained open became an absolutely critical task. As you can see, it passes through the eastern panhandle of what is today West Virginia and goes through Martinsburg after passing through Harper's Ferry and Cumberland. So consequently, Berkeley County and Jefferson County, in what is today the Panhandle, became essential to maintaining the security of the railroad. And in fact, here's maps of Berkeley and Jefferson counties, and you can see where the railroad, which basically traverses the same route as the National Road, passes through Charlestown, north of Charlestown, through Harper's Ferry and then on into Martinsburg before heading in the direction of Wheeling. Because of this, there was a large contingent of Union soldiers, roughly 10,000, commanded by a man named Benjamin Franklin Kelly, Brigadier General Benjamin F. Kelly, that became known as the Railroad Division. And the whole purpose of the Railroad Division was to guard and protect the Baltimore and Ohio Railroad from Confederate raids, of which there were numerous over the course of the war. And if that's of interest to you, we've got them documented in the book. Because Jefferson and Berkeley counties were part of Virginia, they were largely occupied by Union troops. And those Union troops were there in order to maintain the integrity of the Baltimore and Ohio Railroad. So that when the events began to accelerate and a referendum was conducted to determine whether the western counties of West Virginia should secede from Virginia to create a new state, Jefferson and Berkeley counties weren't permitted to vote. Why? They were occupied by the U.S. military. This is the reason for some of the constitutional law issues that Ed will be discussing with you later. That referendum passed, so the next step was that there had to be legislation passed by the United States Congress. First to take it up was the House of Representatives. This is Representative John Bingham, who was at the time the representative of the district where Ed grew up in southeastern Ohio. John Bingham was a zealous advocate for the creation of West Virginia, was one of the sponsors of the legislation in the House of Representatives and argued for it vehemently. Another supporter was Thaddeus Stevens, the leader of the radical Republicans in Congress, representative of Pennsylvania. Thaddeus Stevens was, like most of the radical Republicans, most interested in ensuring that any new states admitted to the Union were not going to be slave states, and there was some compromise that had to be made. However, after a great deal of discussion, the United States House of Representatives passed the legislation and it went to the Senate. This is Senator Charles Sumner of Massachusetts. Those of you who know your American history may know that Sumner was beaten in the Senate chamber by a Southern senator prior to the outbreak of the Civil War and was severely injured. He recovered and returned to his seat. Sumner refused to allow any slave territories to be added to the Union. And there were, in fact, slaveholding portions of what was to become the new state of West Virginia, some of them being in the Greenbrier Valley as an example, some of them being in the Eastern Panhandle. And there was slavery throughout the state. So Sumner's position was, we will not even consider this legislation if there's going to be slavery in the new state. So after a great deal of compromise and decision, a compromise was ultimately enacted. And the compromise was that there would be gradual emancipation of the slaves in the new state of West Virginia. And that as long as that happened, and there was a definite cutoff for when slavery would end, Sumner supported it. And in December of 1862, the legislation passed the Senate after having passed the House in the summer of 62. So that meant that the bill was delivered to President Abraham Lincoln for his signature. His friend Senator Orville Browning, a Republican from his home state of Illinois, was the one who brought the bill to Lincoln. And Lincoln had concerns. He was, those of you who have studied Lincoln at all undoubtedly know that Abraham Lincoln was a very skilled and very astute lawyer, and he had concerns about the constitutionality of these events. Specifically, the concern was that the consent to the splitting of Virginia was given by the restored government, which at the same time was being advocated as being the government of the new state of West Virginia. So you've got the same entity giving consent to the dismemberment of the Commonwealth of Virginia. This greatly troubled Lincoln for good reason. There are real questions about the constitutionality of it. So rather than sign the bill immediately, Lincoln decided to poll the members of his cabinet. There were at the time only 6 members of the cabinet instead of the normal allotment of 7, largely because the Secretary of the Interior, a fellow by the name of Caleb Smith, had recently resigned his position as Secretary of the Interior to accept an appointment as a federal judge in Indiana, and no successor to him had yet been appointed. So instead of there being 7 cabinet officers at the time, there were only 6. So Lincoln decided to poll his cabinet officers, and he asked them 2 questions. Is the legislation admitting the new state of West Virginia to the Union constitutional? Number 1. And if it is constitutional, is it expedient to admit the new state? He asked all 6 of his cabinet officers to provide them their opinions in writing. And how do you suppose they came out? If you predicted 3-3, you're correct. And that outcome really frustrated Abraham Lincoln, who wondered out loud why he had a cabinet if they couldn't reach a decision. So among the 3 who supported the idea of admitting West Virginia to the Union were Secretary of State William H. Seward, again, one of the leaders of the Radical Republicans, Secretary of the Treasury, Salmon Portland Chase of Cincinnati, Ohio, another one of the founders and leaders of the Radical Republicans. Salmon P. Chase will play a major role in this story as it progresses. And the third was Secretary of War Edwin McMaster Stanton of Steubenville, former United States Attorney General in the last few months of the Buchanan administration, known as one of the very finest of the trial lawyers in America. Stanton was a zealous advocate for admitting the new state to the Union. And all 3 of these cabinet officers wrote opinions indicating that it was constitutional and expedient. And interestingly enough, Stanton's determination basically was that the ends justified the means. And it didn't really matter because the ends justified the means. Opposing, Gideon Welles, the Secretary of the Navy, whom Lincoln called Father Neptune. Father Neptune had real concerns with the constitutionality of things. Second was Montgomery Blair of Illinois, the Postmaster General of the United States, who also opposed them. But most importantly, in opposition was Secretary General Edward Bates. And Bates had been arguing loudly and longly against the constitutionality of this legislation from the minute it was introduced in Congress. He believed, and probably correctly, that this charade that had been put in place to have the same entity consenting to the creation of the new state that was going to be the engine of government for the new state presented real constitutional problems, and Bates made his opinion clearly known. So you've got a 3-3 split amongst the 6 cabinet officers. Now, Lincoln himself had written his own opinion, and Lincoln, being the fine lawyer that he was, had written opinion that came to the conclusion that secession in favor of the Constitution was acceptable, whereas the secession of the Commonwealth of Virginia to leave the Union was against the Constitution, and that if he had to choose, that secession in favor of the Constitution was better than secession against the Constitution. And he therefore found the legislation to be not only constitutional, but expedient as well. Excuse me, I am so sorry. The reason why the expediency decision was made is because it had been made clear to him by Governor Pierpont, by Arch Campbell, the publisher of the Wheeling Intelligencer newspaper, and others, that if he vetoed the legislation, that would bring an end to the cause of unionism in West Virginia. And Lincoln couldn't bear that thought. So with that in mind, he found everything to be expedient. He signed the legislation on New Year's Eve, 1862. But the legislation had a contingency in it, and the contingency was that the compromise that had been worked out with Senator Sumner regarding the gradual emancipation of the slaves had to be approved by the voters of the new state of West Virginia as an amendment to the Constitution that had been prepared. that the statehood of the would take effect 60 days after the referendum was held. So the referendum was put together. It was held on the 23rd of April of 1863. The voters of the new state of West Virginia, less those in Berkeley and Jefferson counties, all voted to approve the amendment to the Constitution. So therefore, on June 23rd, 1863, Arthur I. Borman was inaugurated as the first governor of the new state of West Virginia. That ceremony was held in Wheeling. Wheeling became, for a time, the capital of the new state. The Lastly Institute's buildings were basically shanghaied and turned into the seat of the new government. And Borman took his office as the new governor of West Virginia. Now, along the line, Senator Waitman Willey had been a full-throated, enthusiastic advocate of the bringing of a new state into being. John Carlyle, by comparison, became increasingly opposed and took every step that he could along the way to drag the process out, to try to throw hurdles in. He never explained his reasons. He refused to resign his office. He remained in office despite the fact that he was vigorously opposed to the creation of the state that had sent him to the Senate. And it was quite a scandal. But the new government needed to be put into place. And once it was put into place, an entire governmental mechanism had to be developed. That included, but wasn't necessarily limited to, creating a Supreme Court for the state of West Virginia. Common pleas courts were already in existence. They were leftovers from the Virginia system, but there had to be a Supreme Court of West Virginia created. Interestingly enough, the Supreme Court of Virginia, once a year for a month at a time, would meet in Lewisburg in Greenbrier County. And as a consequence, there was in order so that the justices could work there while enjoying the spas of the Greenbrier, they had to have a full law library in Lewisburg. And the Union High Command became aware of the existence of that law library, and a significant cavalry raid was planned and executed for the purpose of seizing that law library and bringing it to Wheeling and having it serve as the nucleus of the law library for the new Supreme Court of West Virginia. Confederates caught wind of that raid. They successfully blocked the Union cavalry's approach to Lewisburg and at White Sulphur Springs. On August 25th and 26th of 1863, a pitched two-day battle took place between that Union cavalry and Confederate infantry commanded by Colonel George S. Patton, the grandfather of the great World War II general. Patton defeated and repulsed that Union cavalry, and that law library was then packed up and sent to Richmond, and never did get the benefit of becoming the basic law library for the creation of the Supreme Court of West Virginia. That's just a sidebar, but it's an interesting sidebar. In the meantime, with the new state having taken its place in the Union on the 23rd of June of 1863, Francis Harrison Pierpont, still the head of this allegedly restored government of Virginia, transferred his operations to Alexandria across the river from Washington, D.C., safely in Union hands, and purported to govern the Commonwealth of Virginia from Alexandria. He was not terribly effective in doing so, and with that, I will step aside and turn it over to Ed and allow him to begin to talk to you about the events that took place in the days after the surrender of the Confederate Army at Appomattox on April 9, 1865. Ed, it's all yours.
Thank you, Eric. And Sean, thank you very much for putting this together. And thanks to the Ohio County Library. I should get a brief word in about our third author, Penny Barrick. I had the pleasure of working with her. Usually we do these programs together, but with the limited time, it's hard to have three people talking about the same material. But she is a full partner in this book. So Eric took us up to the end of the Civil War. And if we think at the time West Virginia was created, Virginia did not have a stake in the United States government. It had withdrawn. It no longer had senators or representatives in Congress. It certainly could not petition the United States Supreme Court. So this whole issue of West Virginia statehood and any claim of the illegality of it had nowhere to go. But by April of 1865, as Eric just mentioned, the war was coming to a close. I thought I'd begin with a picture of what downtown Richmond looked like on the day the Confederates abandoned the city. Sean has promised to be my audiovisual assistant here. Maybe he can put up the first slide. Maybe not. Sean, are you there? All right, well, we'll skip that, but I can tell you that Richmond had been under siege for 8 to 9 months. The city was destroyed. Much of Virginia was destroyed. The state was a mess, and it was occupied by well over 100,000 U.S. soldiers. Eric mentioned Appomattox surrender took place on April 9th. Just 2 days later, which would also be 3 days before Lincoln was shot at Ford's Theater, the Chief Justice of the United States, Salmon P. Chase, wrote a letter to Lincoln. And Eric just mentioned Chase had been the Secretary of the Treasury, and he had been a strong proponent to Lincoln of West Virginia statehood. But let's look at the letter he wrote. It gives us some insight into how he and Lincoln looked at West Virginia statehood. Because even before the war was over, he writes to Lincoln and tells him, as to Virginia, you know how this all happened and the issue of West Virginia. But what had to be created as somewhat of a legal fiction was that the government that was organized in Wheeling was also the government of Virginia, because the rest of the state was in rebellion. And as Eric mentioned, Governor Pierpont, who was from Morgantown, which is in West Virginia, was proclaimed as the governor of Virginia and then went to Arlington during the war and only ruled that part of Virginia held by the U.S. Army. But this letter from Chase to Lincoln made it very clear that, look, to maintain the legitimacy of West Virginia, we need to make sure that acting government of Virginia under Governor Pierpont really is recognized as the true government. Otherwise, the trick that we did here isn't going to work. So to back up for a moment, let's take a quick look at the Constitution, because it does have a paragraph that talks about how new states may be created. It's pretty simple. It's in Article 4, Section 3. New states may be admitted by the Congress into this union. And this is the key language, but no new states shall be formed or erected within the jurisdiction of any other state, then skipping ahead, without the consent of the legislatures of the states concerned, as well as that of Congress. So it's a pretty simple formulation. If the state wants to break in two, the new state has to have a legislature that approves, but most importantly, the state being divided, in this case that would be Virginia, has to consent, and then later the Congress of the United States has to consent. So what Eric was talking about was this question of, did Virginia consent? Now, there were a lot of debates in Congress about this. The 6 cabinet members debated this. Lincoln was of the view, and so was John Bingham, that the only loyal people in the state of Virginia were those who had met at the Wheeling Conventions. Those who had rebelled against the Constitution couldn't be really counted as voters, as legitimate office holders, so that the only government to give consent was the government in Virginia. But then that begets the question of, was this really the consent of an entire state of Virginia, or was it just a rump legislatures that had been formed really from whole cloth? There was no existing structure. The delegates in Wheeling simply had to put it together. Need to back up for a moment to see how complicated this all became. Let's take a quick look at the election of 1864, which is the next slide. This is something easy to forget, but in the middle of the Civil War, Lincoln had grave doubts about his own election. He was only running in the North, of course, There were Republicans that supported Lincoln, and there were Democrats, some of whom supported Lincoln, some of whom wanted to end the war, such as the former governor of Ohio, John Vallandigham. So there was a lot of opposition. And Lincoln did something that had never happened before or happened since. As a Republican running for re-election, he formed a fusion ticket with a Democratic governor of Tennessee, Andrew Johnson. So we have a Republican for president, a Democrat for vice president, and they get elected. I think you'll be surprised when you look at the popular vote. It was pretty close considering how popular we now think of Abraham Lincoln as being. The Electoral College wasn't close, but the popular vote was. So on March 4th, that's when the terms of office used to start for president and vice president. Lincoln was sworn in, Andrew Johnson was sworn in. This was probably the worst decision Abraham Lincoln made in his tenure in office, because just 5 weeks later, he's murdered at Ford's Theater. And an overwhelmingly Republican Congress is now dealing with a Democratic president, Andrew Johnson, who frankly was a poor president by all accounts. And truthfully, the Democrats who otherwise might have supported him viewed him as a traitor. So he came into office with two things. One, very little support, and two, a very different role of how the southern states would be reconstructed than were the views of the Republicans running the Congress. So first thing he does is look at Francis Pierpont, the head of the provisional government of Virginia in Arlington, and he directs him now to become the governor for real of all of Virginia. And a few weeks later, he goes to Richmond, and you saw the picture. Richmond would have looked the same when he arrived there. And one of the first things he did was meet with the Confederate state legislature, which outraged a number of people in the North, particularly the Secretary of State, Mr. Seward. And then what he also did later that fall, Congress is out of session. He holds an election in Virginia where only whites can vote and former Confederates can vote. So you could imagine the type of legislature they elected in October. And they meet on December 6th, 1865. And this is before Congress comes along and says, this is not how we're going to let the South be reconstructed. So this is the president out on a limb, and Francis Pierpont is following him. The very first day the General Assembly meets in the aftermath of the Civil War, the Virginia General Assembly votes unanimously, both the House and the Senate, to rescind the consent of the creation of West Virginia. They reject it. It's one of the biggest burrs in their saddle from the Civil War, other than the devastation and deaths, and they want it reversed. And every couple of weeks, things were moving very quickly. By January 19th, they create a committee to at least determine who's going to pay some of this debt that Virginia had incurred for what's now West Virginia. And then they ask the General Assembly to appoint a committee to negotiate, to give you some sort of flavor of the sort of speeches being given. There was a committee appointed, and it was chaired by a gentleman named Musco Garnett, and railed against the creation of West Virginia, talking about how ungrateful the people in West Virginia were to all the sacrifices Virginia made to bring that state up by its bootstraps. They called West Virginia forgetful of its past, and that someday they will bitterly reject being removed from the state of Virginia. What the legislature also did was to take the two counties Eric focused on. This would be Jefferson and Berkeley counties. The capitals, the county seats of both of those counties are towns you know of. One is Harper's Ferry, and one is Martinsburg. By the way, both of them, as Eric mentioned, are on the other side of the Alleghenies. They're not really the western part of Virginia, but they are railroad counties, and that was very important during the Civil War that the B&O be in Union hands. But to go back and look at how they voted for Jefferson County, where Harper's Ferry is, you can see way back in May of 1861, this county was overwhelmingly in favor of seceding. And then when the statehood vote took place a year later, it was occupied by Union troops. The Union troops didn't trust the voters there, and they did not vote. As Eric mentioned, West Virginia was admitted as a state, and these two counties, Jefferson and Berkeley, were allowed to vote in the future and then future action would be taken to make them part of the new state if they supported statehood. And then with Berkeley County, which is the next, you can see Berkeley County did vote against secession. There was a substantial vote for it. Then they had a much smaller vote in the special election for the statehood, just in these two counties. You can see it's overwhelmingly for statehood, but at the same time, a very small vote. And what you'll see in the lawsuit that follows, Virginia claimed that was so simply because so many people were out fighting for the Confederacy from that county. And by the way, to vote in those days meant you showed up in front of a panel of people running the polling station, and you had to verbally tell them how you were voting. So the people who voted against secession had to be pretty hardy people because there were Union troops all over the polling stations, but at least 7 people didn't think that that was a bother. So Virginia then votes to rescind the recognition of these two counties leaving. And then shortly thereafter, Congress went ahead to be careful and voted to put them into West Virginia after all. So we have this standoff between the Virginia General Assembly and Congress, and then ultimately Virginia decides to bring a lawsuit in the Supreme Court headed by Salmon P. Chase, who has already expressed an opinion about the legitimacy of the government of West Virginia. But I will tell you, as a jurist, that he stayed in the case. You'll see he played an important role as the lawsuits filed. So in early 1866, Virginia files a lawsuit in the United States Supreme Court. And that's a big deal for a couple of reasons. The Article 3 of the Constitution that creates the Supreme Court gives the Supreme Court very little what's called original jurisdiction. We think of them as a court of appeals where cases from lower courts percolate upwards. But there are a very tiny sliver of cases that can begin and end in the Supreme Court. And one state suing another creates what's called original jurisdiction in the Supreme Court. So if Virginia were a state and disputing the creation of West Virginia, the Constitution pretty clearly says it can bring a case in the United States Supreme Court. The problem was, what was the status of Virginia in 1866? Congress had refused to seat any representatives or senators from the 11 Confederate states. They had not been readmitted. They did not vote for president in 1864, and a few of them didn't even have the right to vote in 1868, although that's when the states were starting to come back. And this is where the president and Congress had very differing views of exactly how these states should be readmitted. So the very first issue the Supreme Court would have to consider in this case brought by Virginia, is Virginia even a state? Does it really have a functioning government that has the right to bring a suit? The lawsuit itself was odd because it was, first of all, it was brought up by, there's a picture of Benjamin Curtis, who represented Virginia. And he was a very prominent jurist. He had been on the Supreme Court himself. He wrote a very vigorous dissent in the Dred Scott case and was so disgusted by it that he quit. But in the 1860s, he had become a very prominent private practice lawyer, and he represented Andrew Johnson in the giant impeachment trial that went on during the same time period as Congress tried to divest him of the presidency. But he had a needle to thread here. You have the governor, Pierpont, who had actually certified the vote in Berkeley and Jefferson County back in 1863 and found that they should be part of West Virginia, and he let them go. But now he's the governor of the state that's bringing a lawsuit objecting to these two counties. And Mr. Curtis had to make the argument. And what he did was basically say that the governor had no idea of all the fraud in the election. He couldn't have known. So therefore, these two elections should be vacated. What was interesting, and I found no primary source to answer this, we can only look at inferences, but for whatever reason, Virginia voted to contest only the two counties on the eastern side of the mountains. They did not bring up Article 4, Section 3. They did not make a frontal attack on the very creation of West Virginia, only part of it. It could be that because the Union Army still occupied the state and that the governor was serving at their pleasure and the national government's pleasure, that they saw no point, and also that they saw a more and more resistant Congress to any sort of reassertion of the rights of former Confederate office holders, that perhaps they thought this was the more prudent route. What happened, West Virginia also hired someone very prominent, a gentleman by the name of Reverdy Johnson, who actually was a sitting United States Senator. Very interesting character. He was a sometime friend of Abraham Lincoln. At the end of the Civil War, he represented Mary Surratt in a murder trial. You may remember she was the person who owned the inn where Booth and others conspired to commit murder on a number of high-ranking officials, including Abraham Lincoln. He lost that case and she was executed. And he also volunteered publicly to represent Jefferson Davis. Again, a very interesting person in American history, and did a very interesting job in the Supreme Court. Now to the Supreme Court. During the Civil War, the court had been increased to 10 justices. One died in the summer of 1865, and 6 months later, another died. So like Lincoln's cabinet, as West Virginia case was argued in the Supreme Court had an even number of justices. So Benjamin Curtis and Reverdy Johnson were two of the most high-profile, best lawyers in America. They spent 2 whole days arguing the case before the Supreme Court. The Supreme Court took the case under advisement and then 6 months later issued a very cryptic order indicating that they were tied. And I'd mentioned that it was important that this was an original jurisdiction case, because in other cases where there's been a decision from a court of appeals or a district court or a state Supreme Court, then that earlier decision would then become the end of the case. But here there was no such ending because there was no other court that had heard the case. So the record in the Supreme Court simply said, I quote, "The Supreme Court is equally divided upon the order which should issue in this case." And that was that. So with 8 justices serving and a Congress that really disliked the President of the United States, Congress passed the Judiciary Act of 1867, which basically said the court will now have 7 justices rather than 10. The immediate effect of that, the absolute certainty of that, is that Andrew Johnson would not have the ability to fill in anybody on the court, at least over a period of several years, because there had to be 2 vacancies for him to be able to add anyone. You may recall he was not renominated in 1868. The case sat on the Supreme Court docket with the whole issue of these counties and perhaps the whole validity of West Virginia, going through the most contentious time in American history. Again, we're looking at Reconstruction, how the states get readmitted from the South. We're looking at impeachment of a president. And we're looking at a Congress that is very suspicious of the Supreme Court, passing a number of acts that limited the court's jurisdiction and also limiting the court's size. So eventually, Johnson's term runs out. He is not nominated by either party. Ulysses S. Grant is elected in the fall of 1868. He takes office in March of 1869. And immediately, Congress passes a new law. Congress is run by the Republicans, and so is Grant, giving Grant the right to pick 2 new justices. They put the size of the court back to 9. That meant no appointments by Andrew Johnson, but 2 by Ulysses S. Grant. And then finally, at the end of 1867, there's a decision from the Supreme Court. In a 6-3 vote, Virginia lost. But I will tell you, the decision itself was extremely narrow. It looked at the pleadings, which are somewhat technical. It looked at the burden of proof. It did not look at all at Article 4, Section 3. There was no court imprimatur on the idea of the Wheeling Convention being able to create a new state the way it did. And the case, frankly, looked as though the country was tired of all this. It wanted back to normalcy. The Supreme Court represented that tendency, and the case died a very quiet death. Interestingly, not until 1911, many years after the Civil War, Virginia and West Virginia wound up in the Supreme Court again. And this time, a new justice who was almost killed in the Civil War on the Union side, Oliver Wendell Holmes Jr., wrote a blistering description of the Wheeling Convention and basically said it's without dispute that this was done properly and West Virginia is the 35th state of the Union. So go back to what Eric had mentioned. I am of the view that this was constitutional. Lincoln did not want to make West Virginia become a state simply because the Union had more troops in the state. I think he looked long and hard. He looked at the part of the Constitution that said every office holder at every level must swear loyalty to the Constitution. He viewed the people who ran the Virginia government as having breached that oath and were divested of office. And the only legitimate government left in all of Virginia was, in fact, the government created at the Wheeling Convention. Eric's great quote that he used, I'll end with, Lincoln said, "Our enemies will say we're for secession when it's in our favor, but we say there's enough difference between seceding in favor of the Constitution as opposed to seceding in opposition to the Constitution." So as usual, Lincoln gets the last word. Thank you.
Sean, you're muted.
I am indeed. Now I'm not.
Okay.
Thanks to both of you for a great program. I wanted to just see if there were any questions. I do see one question about Carlisle. I'll put it up on the screen.
Question is that although Carlisle didn't explain his reasons for his change of heart in support of the formation of the new state, is there any indication of his reasoning for this dramatic change in his support? The answer is not direct evidence, only some things that you can draw in the way of assumptions from things that he said. And apparently he had issues with the mechanism by which things were done.
Okay.
Issues that troubled Lincoln.
A lot of great comments. Everyone enjoyed the program. We'll just give it a couple seconds, see if there are any other questions. If you have a question, type it in the comment field and we'll get it up, see what we can do.
And I do apologize for the coughing spell in the middle.
Yeah, you have us all worried there. You're okay. All right. I'm not seeing any further questions. I will thank our guests again and remind you that we have a program Thursday evening in People's University. We'll be looking at literature in Nigeria and the Nigerian language of Igbo. That'll be at 6:30 p.m. on Thursday. Thanks again to Eric Wittenberg and Judge Sargus. And thank you to all who watched the program. Take care. Have a nice day.
Thank you.
Thank you.